proceed in the matter of planning and Commissioner for taking the review in custody.
Yes, Mr. Hickey.
My Lord, thank you. I appear on behalf of the appellant and my junior, Ms. Sheldon. My learned friend, Ms. Wilson, appears with Mr. Hatter for HMRC.
Yes.
Can I just deal with a point of housekeeping in relation to the bundles? There are two aspects. First is the core bundle. Hopefully you will have a tab 15 at the very end.
I have a tab 15 in the electronic version, which is a skeleton argument.
Thank you, which was in the upper tribunal. And the second aspect of the housekeeping is that you should have a hard copy of some explanatory notes, which are spiral bound. Thank you.
Thank you for that. Thank you very much. Is that from you or from you both, or is it vanilla?
That's from both of us. My learned friend has had sight of it.
You're happy with that, are you, Ms. Wilson?
Yes, it's in response to the request from the court.
Good.
Thank you.
All right. Well, while you're keeping house, we have a half a day estimate, don't we, for this appeal?
I understood it was 1 day.
Well, let's not worry about that. I think we were told it was half a day, but we're not clock watching. What I'm concerned about is that we will have to finish comfortably before 4 p.m. Regardless of what the official time estimate is. And have you had some discussion between you as to how you'd like to divide the time?
I was proposing to go to midday.
Well, if you don't stray much beyond that, that will be very fair to Miss Wilson. Good. Thank you.
Thank you. Turning to the appeal, if I may, at the outset, it's important not to lose sight of, in our respectful submission, 7 points. The first is the facts of this appeal concern unconnected parties. Mr. Fanning contracted to purchase a property from Glendale Enterprises 4 Limited for £5 million, and he granted an option to San Leon plc, an Irish-listed AIM company, for £100 to purchase the property at its market value. Completion of the contract purchase and the option occurred on the 16th of September 2011. For your side note, that's FTT paragraphs 5, 6 and 9. FTT 5 subparagraph 3. The FTT specifically found San Leon had a business objective.
Is this a numbered point, or still the first one?
It's the first point.
It's the first one. Could I just invite you to keep up your voice a little bit? It may be this court building, it's probably me, but if you would, it'll make it easier to follow.
Thank you, my lord. As part of my first point, First-tier Tribunal, paragraph 5, sub 3, the FTT judge specifically found as a primary fact, San Leon had a business objective in obtaining an interest in the property because it would be available to rent for use by its staff. The FTT decided that the purchase was a mutually beneficial arrangement. Moving, if I may, to our second point in the context of this appeal, it is very important to appreciate that there is no challenge by HMRC to the First-tier Tribunal's findings of fact. And this is Core Bundle 14, my learned friend's skeleton argument, paragraph 3, page 142. And if I can deal with a number of the key findings relating to the option agreement, because obviously it's important to apply the facts to the law, and there are a number of key findings of primary fact made by the FTT in relation to the option. And these are at FTT paragraph 5, 1 through to 18. And if I can deal first with paragraph 5, subsection sub 2, Mr. Fanning had no control over San Leon. It's a company admitted to the AIM Stock Exchange and subject to Irish company law and regulation, as well as the rules, standards and regulations applicable to AIM companies. Therefore, it was an independent third party that entered into the grant of the option. It's therefore with respect, wrong for HMRC to say that the option was granted to a compliant third party. And that's skeleton argument, paragraph 1, page 14, sorry, tab 14, page 142. The FTT concluded that the option was genuine. That's FTT paragraphs 54 to 55. And as to the option, it was a decision for San Leon as to whether or not it would exercise that option in due course, and the circumstances in which the option might be exercised would be as a result of an independent decision of a listed company. Turning to my third point, and this is to the option itself, and if I can invite the court to go to the core bundle, tab 12, page 109. This is the option agreement itself, granted by Mr. Fanning. As you can see from the front page, it relates to the entire property, which is the subject of this appeal. And if you turn to page 110, clause 1.1, you can see the owner, Mr. Fanning, the grantee, San Leon Energy PLC. The property is described in Schedule 1, the option consideration £100, and the option period commencing on the 16th of September 2016 and ending on the 15th of September 2031. So the option exercise period between 16th of September 2016 to the 15th of September 2031 was 15 years. And the overall period in which the land was tied up and subject to the option was for a 20-year period, taking it from the date of grant of the option.
Could I just ask you this? May or may not matter. If this scheme was valid, as you say it was, when, if ever, would SDLT be payable?
SDLT would be payable, my lord, on exercise of the option, and that would be under clause 3 of this option agreement.
You're right, so you're coming to that. Payable on exercise of option, so...
And at market value, my lord.
Sorry?
At the market value of the land, of the property, at the date of exercise.
And if the option is never exercised, will SLT ever be charged?
If the option is never exercised, then SDLT would not be charged, my lord.
Yep.
I make no bones about it, this was an SDLT planning scheme.
Yep.
On our case, it's a matter of SDLT deferral. But as the FTT found as a matter of fact, it was open to San Leon as an independent company to decide for itself whether or not it would exercise the option in due course.
Yes, but this is, so in other words, the scheme, if it's a valid one, which is the whole question for us, is capable either of enormously deferring the time at which SDLT would be payable.
My lord, yes.
And whether it would be payable at all is contingent on a number of matters. Two spring to mind. One is that San Leon would choose to exercise the option, because it might not.
My lord, yes.
In which case the potential tax liability simply goes away. Or if, for example, San Leon ceased to exist.
My lord, yes.
At that point, of course, it would be incapable of exercising the option. And so, by that means also, it goes away.
Yes.
Right, that's very clear, thank you.
But if I might add to those points, which is obviously if San Leon decides to exercise the option, if the price of the property has gone up, then the amount of SDLT that's going to be paid is effectively increased.
Yes, and if it goes down, it's reduced.
Yes.
Yes, but you're certainly, as far as I'm concerned, pushing against an open door when you say that this is not described or found to be a sham. It's not considered to be a transaction between connected parties.
My lord, thank you. I'll move quickly through the option agreement. In that case, on that basis, unless any questions occurred to the court in relation to the option agreement, I wasn't going to dwell on any further clauses. Thank you. fourth point that I want to make out of my 7 is that the issues in this appeal are whether the conditions of Section 45 of the Finance Act 2003, which deals with the transfer of rights as enacted in 2011, are satisfied such that 1, the option granted by the appellant to San Leon is an other transaction within Section 45, subsection 1, and 2, whether the payment of £100 for the option is substantial performance as a deemed secondary contract within Section 45(3). And if Section 45 applies, then the contract between Glendale, the vendor, and the appellant is disregarded under Section 45, subsection 3, and SDLT is calculated solely on the £100 paid by San Leon to the appellant. So that's the focus in terms of the statutory interpretation, which I'll go to very shortly. The fifth point I'd like to make is that, of course, the appellant was entitled to structure the acquisition of the property to save SDLT within the boundaries of what is permitted by the legislation. I don't propose going to the authority, but if I give you the citation, Secret Hotels, Supreme Court, Legal Authority Bundle, tab 23, page 165, paragraph B, and this is per Lord Neuberger. And on that basis of that legal principle, we say the appellant and San Leon were entitled to structure the property purchase as they did to maximise the commercial attraction of the purchase, including the incidence of taxation, and as such to defer stamp duty land tax as the law then existed. The sixth point to make is that it is common ground that the Ramsey approach to statutory interpretation applies to this appeal. The correct approach to deciding whether the stamp duty land tax planning achieved its objective is to ask whether the relevant statutory provisions construed purposefully were intended to apply to the transactions viewed realistically. The Supreme Court recently looked at the Ramsey approach to statutory interpretation in Rosendale Borough Council against Hurstwood Properties, and that's Legal Authorities Bundle, tab 29, page 356, and the principle I've just identified is distilled at paragraphs 13 through to 15, but I don't think I need to take the court to that.
Just going back into Secret Hotels, which paragraph are you referring to? You gave page 165, which I assume is a page of the bundle.
It is, my lady, tab 23.
Sorry, there's a difference between the page numbering.
My apologies. Tab 23, page 100.
Oh, I can see it now. Yeah, it's a different page on the other.
Would you prefer me to give references by
paragraph where you can? Thank you.
Just returning to our sixth point in relation to what I've just said about the Ramsey approach to statutory interpretation. And the effectiveness of the planning falls to be determined by reference to, in our respectful submission, the real-world nature of the legal interests created by the option. The focus for the SDLT legislation is on what is acquired, not on what is disposed of. And the authority for that proposition is Court of Appeal in DV3, Legal Authorities Bundle, tab 22, page 143 at paragraph 23, Lord Justice Lewison. San Leon, on grant of the option, was entitled to an equitable interest, which is clearly an interest in land in the real world, and in our respectful submission counts as a chargeable interest within section 48(1) of Finance Act 2003, and as such is a land transaction within section 43 subsection 1 for the purposes of SDLT. And I'll momentarily go to the legislation.
So it's an equitable interest. It amounts to a land charge and you say it's also another transaction.
My
So all
lord,
three
yes.
things, yes.
Exactly. In the real world, for landlord purposes, it's an interest in land, over land. For SDLT purposes, SDLT applies to a land transaction. A land transaction under Section 42 is the acquisition of a chargeable interest. Chargeable interest is defined in Section 48.
Yeah, but it's an extra interest in land, full stop. You can see one contract. If you protect it by way of a land charge, there'll be another set of legal protections because it'll not be overridden by a sale. And then there's a third set of circumstances, whether or not it amounts to another transaction for SLT purposes.
My lord, yes. Exactly. Just under the heading of our sixth point, it's important to recognise that lacunas have existed in the Stamp Duty Land Tax Code from the time of its enactment in Finance Act 2003. And this was recognised by the Supreme Court in Project Blue, Legal Authorities Bundle, tab 27, page 307 at paragraph 37. And there the Supreme Court said in the early years of SDLT, Parliament created a patchwork of provisions which for a while allowed transactions to result in an unintended tax holiday.
Sorry, can you give me that reference again?
Sorry,
Can you give me that reference again? Apologies.
Yes, Legal Authorities Bundle, tab 27, page 307 at paragraph 37.
Thank you.
Thank you. We say that the planning considered in this appeal was structured to take the benefit of a lacuna involving the transfer of rights rules by granting an option to purchase property.
Is any tax chargeable on the transfer fee? The option
sorry.
fee.
Sorry, could I
Is
ask?
any tax chargeable on the option fee?
No, because it was granted for a consideration of £100.
And what's the threshold?
The threshold is, and it's not in the bundle, but we can hand it up at the short adjournment. It was under Section 55 of the Stamp Duty of the Finance Act 2003. For residential property, it was a nil rate up to £125,000.
Thank you.
But we'll get that section.
No, it's just context.
Thank you, my lord. Sections 44 and 40. Oh, sorry, go back to 1 point first. In relation to the structuring, it's noteworthy that HMRC introduced a new subsection 45(1)A in Finance Act 2012 to make it explicit that the grant or assignment of an option could not benefit from the subsale rules with effect on or after the 21st of March 2012.
But can that affect this appeal? We have to look at what Parliament intended in the initial thing. The fact that Parliament then took steps and did other things, does that help us? Is it even admissible as an A2 interpretation?
My lords, simply for the purposes of context,
Yes.
to make you aware.
It was agreed below that nobody was going to seek to make much
No,
of
absolutely.
this, and it was regarded as a fact. So when you say it's noteworthy, all facts are noteworthy in this court, but it doesn't push.
Yes, my lord, I perfectly accept it can go both ways.
Well, it's not going. As I understand, it's not going anywhere.
No.
It's not even an aid to statutory interpretation. I mean, I think
not.
it's worse than that. I'm not sure that you can normally look at. There is case law about when you can look at subsequent
My lord, I accept
legislation.
that.
There's quite detailed House of Lords authority about
Yes.
that, and you have to show that.
Yeah. So as a matter of fact, you wouldn't be here if this had happened 2 years later.
Yeah.
No,
But it didn't happen 2 years later.
Sections 44 and 45 are deeming provisions which must be construed in accordance with principles summarised by the Supreme Court in Fowler. Could I invite the court to go to Legal Authorities Bundle, tab 28, page 340. And it's paragraph 27. And the principles are set out between D and G as sidelined. And as you can see, D1, the extent of the fiction created by a deeming provision is primarily a matter of construction of the statute in which it appears. 2, for that purpose, the court should ascertain, if it can, the purpose for which and the persons between whom the statutory fiction is to be resorted to, and then apply the deeming provision that far, but not where it would produce effects clearly outside those purposes. 3, that those purposes may be difficult to ascertain, and Parliament may not find it easy to prescribe with precision the intended limits of the artificial assumption which the deeming provision requires to be made. 4, a deeming provision should not be applied so far as to produce unjust, absurd, or anomalous results, unless the court is compelled to do so by clear language. Then 5, that the court should not shrink from applying the fiction created by the deeming provision to the consequences which would inevitably flow from the fiction being real. Thank you. And then, if I can turn to our 7th point in opening, this is obviously an SDLT case, and necessarily we are concerned with the provisions of Finance Act 2003. SDLT is concerned with the taxation of rights in or over land which are identified in the legislation as the acquisition of a chargeable interest, and as such a land transaction within section 42 is subject to SDLT. And if I could invite the court to pick up the explanatory notes, which are in the spiral bound supplementary bundle at pages 1 and 2. So these are the explanatory notes to Finance Bill 2003. And as you can see at the top under summary, clause 42, this clause introduces stamp duty land tax as a replacement for the current stamp duty charge on land and buildings in the UK. It clarifies the revised regime will apply irrespective of how the transaction is documented and whether it's concluded in the UK or elsewhere. And at page 2, paragraph 9.
Well, it may be worth pausing on paragraph 5, background, which focuses on the fact that this is a charge on transactions rather than documents.
Yes.
Yep.
And turning the page.
Shall we read 9 to ourselves?
Oh, yes, thank you.
But your thesis here is that effectively, at least in the here, in the moment when the vendor divested themselves of this property, the statute drives to the conclusion that instead of there simply being a sale of the property, as it might have appeared to the vendor, it was something entirely different as it appeared to the purchaser. Namely, instead of being a large sale, it was the creation of a small option. And that's
my lord.
that's
In a nutshell, this planning relies on
yes.
The point that
It's not a large sale; it's actually a small option. Yes.
Yeah. Okay. But of course, if the planning, which we say, does work, whether it's granted for £100 or £1 million,
I've got that.
My lord, thank you. The statutory provisions emphasise that the Stamp Duty Land Tax Code applies to real-world property transactions. And if we could turn now to the legislation, in the Legal Authorities Bundle, tab 3, page 8, section 42.
Could I just, for future reference, I don't mean this unkindly. This bundle has the same pagination as the electronic and paper bundles. I think we're all on tab 8, but the other one doesn't. It has a gap. Could those producing bundles in future cases try and make sure that
This one?
No, the big bundle, that our core bundle is 4 pages apart. Just, I don't mind working 4 pages apart, but then I have to move between one and the other. So I think the point is taken, and I'm very grateful to those who've read the bundles anyhow. All right, so we're on page 8 of the authorities.
I think it departs later on in the bundle. The notation departs. That's what stuck me. It caught me out earlier.
All right, so there's a sophistication later on. It doesn't matter.
So Could I just check? So tab 3, and hopefully bookmark
Yes.
3, is section 42.
It is.
And is that's page 8 in the printed version?
Yes.
Yes, and in the electronic version at this point. Right. So on you go.
Thank you. So section 42 sets out the charge to tax. A tax shall be charged in accordance with this part on land transactions, and subsection 2 makes the point tax is chargeable whether or not there is any incident affecting the transaction. If you have to hand also the explanatory notes, pages 3 and 4.
Yes.
The explanatory notes deal with clause 43 in relation to land transactions, and at the top, paragraph 1 makes the point that this clause sets out the definitions of land transaction, vendor, purchaser, and main subject matter, which are used for the purposes of SDLT. And then if you turn to page 4, under background, I won't read it out, but if I could invite you to cast your eye through paragraphs 8 to 10, it emphasises the very broad nature and scope of SDLT. In relation to what is a land transaction. And then if you tie in the explanatory notes with Legal Authorities Bundle, tab 4, page 9, section 43 gives you the definition of land transaction, which means in subsection 1, any acquisition of a chargeable interest. And as to the meaning of chargeable interest, see section 48, which we'll go to in a moment. But for your side note, that's at tab 9. Subsection 2, except as otherwise provided, this part applies however the acquisition is effected, whether by act of the parties by order of the court or other authority by or under any statutory provision or by operation of law. And of course, in relation to this planning, the interest was affected by the option grant. 43 subsection 3, for the purposes of this part, the creation of a chargeable interest, and that's what was created through the option on our case. The legislation says the creation of a chargeable interest is 1, an acquisition by the person becoming entitled to the interest created, that would be San Leon on these facts, and 2, a disposal by the person whose interest or right is subject to the interest created. And of course, that is Mr. Fanning's interest in the property. If I could then move through to section 43, subsection...
But before we leave 43,
Sorry.
it's also right that the sale by the company to Mr. Fanning would also be a land transaction within section 43, and the question is whether or not that's knocked out by the later transaction. So we can't just look at, the transaction that you're concerned with, we have to remember that there is clearly a land transaction, the sale, and then we have to look at if there's another land transaction within the meaning of the subsequent statute.
My lord, absolutely, yes. And
right.
that will be an issue in terms of the application of section 45 and how it modifies section 44. Just for more than completeness, section 43, subsection 4, page 10, references in this part to the purchaser and vendor in relation to a land transaction are to the person acquiring and the person disposing of the subject matter of the transaction. So with the option, we had a purchaser and a vendor, and of course I recognise there was a vendor of the property itself and a purchaser in the form of Mr. Fanning. So multiple parties wearing different labels. Subsection 5, a person is not treated as a purchaser unless he is given consideration for or is a party to the transaction. And of course, consideration was given by San Leon in relation to the grant of the option. And I also recognise that consideration was given by Mr. Fanning. And the key issue there to the vendor, the key issue there is what is the effect of section 45? Does it disregard the original contract? And then subsection 6, references in this part to the subject matter of a land transaction are to the chargeable interest acquired, the main subject matter, together with any interest or right appellant or pertaining to it that is acquired with it. If I could then turn to tab 9 in the bundle, which should be page 19. That's section 48, chargeable interest. Subsection 1, chargeable interest means an estate interest, right or power in or over land in England, Northern Ireland, or the benefit, an obligation, restriction or condition affecting the value of any such estate interest, right or power other than an exempt interest, but we don't need to deal with exempt interest. If I may, I'm going to go now to section 44, but I think it's helpful to look at the explanatory notes first. So if you take up the explanatory notes, you go to what should be page 5. At the top of the page, it should say 44, contract and conveyance. Yes. And paragraph 1. This clause relates to contracts for land transactions. If such a contract is substantially performed before it is formally completed, then a charge to stamp duty land tax will arise at the time of substantial performance, defined broadly as payment of most of the consideration or taking possession of the property. If such a contract is substantially performed only at the time it is formally completed, then a charge to SDLT will arise at the time of completion. And then page 6, if I could invite the court to read the background.
Yes.
Thank you. And then, if we could go to the legislation, which is at tab 5, which should be page 11. Section 44, contract and conveyance. So, one of the key provisions within the Stamp Duty Land Tax Code, but of course has to be read with the wider provisions within the legislation. Subsection 1, this section applies where a contract for a land transaction is entered into under which the contract is to be completed by conveyance. And of course, absence any planning, that would be the contract entered into between the vendor and Mr. Fanning. Would bring this straight into operation. Subsection 2, a person is not regarded as entering into a land transaction by reason of entering into the contract, but the following provisions have effect. So simply entering into a contract is not a land transaction for SDLT purposes, other than as provided by what follows. Subsection 3, if the transaction is completed without previously having been substantially performed, the contract and the transaction affected on completion are treated as parts of a single transaction. In this case, the effective date of the transaction is the date of completion. So, absence any planning, Mr. Fanning had just simply acquired the property from the vendor, paid consideration, we would have been within section 44, subsection 3. And for the purposes of context, the effective date is important because the effective date relates to the time for payment of SDLT and the filing of the return. So, as at the time this planning was entered into, a land transaction return would have had to have been filed within 30 days of the effective date, and any SDLT due was then payable at that time. And that was a combination of sections 76 and 76 and 86 of Finance Act 2003. And the definition of effective date is given at section 119, subsection 1, and typically that's completion, but it's modified to the extent other provisions give a different effective date, as you'll see in a moment.
If we stopped at the end of clause section 44, the only transaction capable of being a land transaction is the contract for sale between the company and Mr. Fanning. You need to go on to another section
My lord,
to
yes.
supply, don't you? So the starting point is the only transaction within section 44 is the initial sale.
My lord, yes. Yes. Then the question is, what is the effect of the option, and how does that modify section 44?
Yeah.
But I'll just go through the other main subsections within 44 give the overall picture, if I may. Subsection 4, if the contract is substantially performed without having been completed, the contract is treated as if it was itself the transaction provided for in the contract. In this context, the effective date of the transaction is when the contract is substantially performed. Now, just pausing there, if this court accepts that the grant of the option is an interest in lands such as to engage section 45(1), the question will then arise as to what is the effect of section 45 subsection 3, which deems there to be a secondary contract. But once you've identified the secondary contract, which would be between Mr. Fanning and San Leon,
Well, it doesn't actually say
the
that,
question
but we'll
then
come
is
back to that.
how. Sorry, my lady.
It doesn't actually say who the two parties are, but we'll come back to that.
The question would then be how section 44 subsection 4 is modified. So if the contract is substantially performed as it reads now, and you accept 45 free is engaged, it would then be going back to section 44 to say if the secondary contract is substantially performed, and on our case the secondary contract is the grant of the option and payment of the £100.
Yes, but it can't be. I mean, at the moment, the only contract he's talking about here is we've established the sale. At this stage,
My lord,
nothing in
yes.
44 applies to
My lord, yes.
the transaction. And I thought 44.4 was dealing with situations like, for example, you have a contract, you move in, but you never get round to the conveyance. That would be within
Yes,
44.
my lord, yes.
So it's not, can't be dealing with 45 yet.
I simply flagged the point in terms of coming back to it, but my lord is exactly right. In the paradigm case, in terms of purchase and sale of property,
It would be occupation.
yes, it would be occupation. Well, slightly more than occupation.
Well, that's one example. It's not
Yes.
the only example.
Yes, no, absolutely. And say 44 subsection 5, contract is substantially performed.
Oh, there it is, yes.
Yeah, when the purchaser or a person connected with the purchaser takes possession of the
Yes.
whole of the subject matter of the property, or B, a substantial amount of the consideration is paid or provided. And then you can see just over the page, should be page 12, subsection 7, for the purposes of subsection 5B, a substantial amount of the consideration is paid or provided, A, if none of the consideration is rent, where the whole or substantially the whole of the consideration is paid or provided. And then, if you cast your eyes down to subsection 10, in this section A, references to completion are to completion of the land transaction proposed between the same parties in substantial conformity with the contract, and B, contract includes any agreement and conveyance includes any instrument. Turning then, if I may, to section 45 in outline, but again I think it's going to be helpful to look at the explanatory notes first. If I could invite the court to go to what should be pages, well, starting at page 8, you should see at the top of the page, titled Clause 45, Contract Conveyance Effective Transfer of Rights. 1. Under summary, this clause deals with the treatment of sub-sales and other situations where the purchaser's rights under a contract are transferred to a third party. The basic rule is that each transfer of rights will be charged to stamp duty land tax. The government will be consulting on possible targeted replacements for the sub-sale relief that existed under stamp duty. So pausing there, the original proposal for section 45 was actually no form of sub-sale relief, and then a subsequent amendment, and you can see that actually from page 9, paragraph 8. One result of the operation of this clause is that there will no longer be a general relief on sub-sales, but the government will be consulting on possible targeted replacements. If you then turn forward to page 27, you should have at the top of the page a heading, Board of Inland Revenue Finance Bill 2003 Report Clause 45. And under the heading Amendment 55, you can see what is now and was enacted as Section 45, subsection 3, where the government introduced subsale relief for a transfer of rights. I'll come back to the actual legislation in a moment, but if you then go to page 28, paragraph 1, these, under the heading Summary, these amendments A, clarify the charge on a person who takes a transfer of rights under a contract for a land transaction, and B, give relief in certain circumstances to intermediate contracting purchasers where there is such a transfer of rights. 2, clause 45 deals with the situation where there is a contract for a land transaction and the contracting purchaser transfers his rights under the contract, whether by subsale or assignment, without himself completing. Under the clauses originally drafted, there was always a charge on the contracting purchaser, or at the latest, when the transferee completed. Paragraph 3, these amendments provide that there is no charge on the contracting purchaser unless he himself completes or the contract between him and the vendor is substantially performed within the meaning of clause 44.4. For this purpose, an act of completion or substantial performance which takes place in connection with and at the same time as completion or substantial performance by the transferee is ignored. And then finally, at page 29, paragraph 5, the amendments also clarify the charge on the ultimate purchaser is deemed to have entered into a contract for a land transaction under which the consideration is, in effect, the total consideration given by him, whether to the vendor or to the intermediate contracting purchaser. The transfer of rights is not itself a land transaction, save he is chargeable only when the transaction is completed, or if earlier, when there is substantial performance of the deemed contract.
What was the transfer of rights in this case?
The transfer of rights in this on this appeal is the grant of the option, my lord.
But they're not the same rights.
No.
They're not the same rights. And I appreciate these are explanatory notes, and when we come to 45, you'll help us to the extent as to which transfer of rights is a useful concept. But if we're understanding what the purpose is, it doesn't say transfer of one set of rights and then a transfer of a completely different set of rights. So is there something that you need to be helping us about there?
My lord, when I come to the legislation, if I work through it step by step, if I may, on
by all means, because you'll certainly need to do that for me, but you're obviously content with the fact that if we're looking at the purpose of the thing, then the purpose is declared to concern what happens when there is a transfer of rights.
My lord, yes, but if I can take you to one further set of amendments,
please,
which is page 32, and at the top of it you should have Finance Bill 2004, Schedule 37.
Could you just give the reference again? 32, did you say?
Page 32, my lord.
Yes, thank you.
And this is Schedule, top right, you should see the heading Finance Bill 2004, Clause 282, Schedule 37.
Mm-hmm.
And then if you go down to paragraph 9, starting with the second sentence, paragraph 5 deals with the transfer of rights under a section 44 or 44A contract. We don't need to worry about 44A. Going to 9A, subparagraph 1 introduces amendments to section 45 dealing with the transfer of rights under section 44. I'll come to this in the legislation, but it's really B I want to go to, and the underlining under subparagraph 3 states it deals with the transfer of rights over part only of the subject matter of the original contract. So this is referring to what your lordship will see in a moment as being section 45 subsection 5. The last sentence of section 45 subsection 3 applies where there is a contract between A and B. So for example, in our case, vendor and Mr. Fanning. B subsells or assigns to C, and on our case, that's Mr. Fanning subselling, transferring a right to San Leon C, and the sale to sea.
I read subsales or assigns as transferring the legal title in the property, not the grant of an option, which may or may not be exercised.
I'll
Sorry.
Okay,
sorry.
No. I can come directly to the legislation now.
Oh.
Yes.
Okay, can you just give us some context? What, because I think we need to understand what point are you trying to make on this paragraph?
It's simply the point where they say the last sentence of section 45 subsection 3, this is the tailpiece of section 45.3, which
Yes.
we'll see in a moment, the nature of the disregard, applies where there is a contract between A and B, B subsales or assigns to C, and the sale to C is completed without earlier substantial performance of the contract
Yes.
between A and B. In such a case, there is no charge to B. And this point, there's no charge on Mr. Fanning.
Right.
If
Okay.
he falls
well,
within that, yes.
Yeah, so you say he's within that.
Yes,
Yeah.
precisely. But it was just to go through what we have in relation to the explanatory notes, and I was
I
conscious
see.
of the fact that
Right. Just to reassure myself, I know we're going to be looking at legislation and there are limits on the extent to which you could use the explanatory memorandum. But if I was going to construe, as I probably shouldn't, the explanatory notes, I wouldn't regard a subsale or an assignment as including an option, because I think of a subsale as handing on, selling that which I've bought, and I include an assignment as assigning that which I've bought, and that which I've bought was the lease.
my lord, yes.
So it doesn't look as if I was to look at that, as if it tells us anything at all about the situation here.
My
Whether
lord,
the
yes.
absence is significant
Yes.
is another question.
Yes, I need to do work on the
Right, okay.
legislation.
So I haven't understood assigns or subsales. Right, okay.
But I found it important given the request for the excited
Thank
explanatory
you.
notes last
That's
Friday.
helpful.
I will turn, I promise, to sections 44 and 45, but I think I first need to deal with the nature of the interest created by the option, if I may. And on our case, the grant of an option to acquire land creates an equitable interest in land. I won't go through all the cases, but in our respectful submission, there is a long line of authority which establishes that an option to purchase land creates an interest in land with a right to call for a conveyance of that land. If I may, the first case to go to is London and South West Railway against GOM. That is to be found Legal Authority Bundle tab 16. And
Sorry, just to clarify, I don't believe any of these principles are in dispute, and they're well established, aren't they?
in our respectful submission, they are well established, but it's to make good the point in relation to section 45 subsection 1 that the effect of the option is that San Leon had a right to call for a conveyance of the property as a
If it exercised the right,
well,
it gives it the right. If it exercises the right,
But-
the option doesn't convey the property. The option conveys the right
but
to call for the property to be conveyed, doesn't it?
well, the legal principle that we rely on, which we say is set out in London South Western Railway against GOM, is that from the moment the option is granted, it is a fetter on the grantor's ability to dispose of the property.
Mm-hmm.
And can I go directly to the passage?
Yeah,
Yes,
where
please,
where
yes.
is it?
Please. So it's tab 16,
Thank
and
you.
it is, if I could start page 35, just very briefly, and I don't intend to go through the facts in any meaningful detail, but the key issue was whether the grant of an option was void for remoteness under the law of perpetuities, and if the option created an interest in land, it was void, and both courts, High Court and Court of Appeal, held it was void. Hopefully, page numbering is holding up still.
I don't think
It's
so.
not. Tab 16,
No, we're now 4 pages adrift.
page 35. Page 35 should be the head note for London and South Western Railway.
Yes.
My lady, could I ask what the mismatch is?
4.
4 pages.
Thank
So we're now at page 39 electronically,
Thank you.
which I think holds out later in the bundle.
Right.
Yes, and the head note suffices just in terms of to get to the key passage of the Court of Appeal. It is at page 54, so page 58 in my lady's e-bundle. And there, the Master of the Rolls tops the page. The right to call for a conveyance of the land is an equitable interest or equitable estate. In the ordinary case of a contract for purchase, there is no doubt about this, and an option for purchase is not difficult in its nature. A person exercising the option has 2 things to do. He has to give notice of his intention to purchase and to pay the purchase money. But as far as the man who's liable to convey is concerned, his estate or interest is taken away from him without his consent, and the right to take it away being vested in another, the covenant giving the option must give that other an interest in the land. It appears to me, therefore, that this covenant plainly gives the company an interest in the land, and as regards remoteness, there is no distinction that I know of between one kind of equitable interest and another kind of equitable interest. In all cases, they must take effect as against the owners of the land within a prescribed period. And that line of authority, if you go to tab 34, which should be the very last tab in the bundle, page 381, but in the e-bundle it's page 385. There are 2 decisions in George Wimpey, Chancery Division, and then Court of Appeal. Court of Appeal affirms the Chancery Division decision. George Wimpey, the issue was in relation to what's the effect of the grant of an option for the purposes of the Stamp Duty Act 1891. And to give you context, page 384, paper copy 388, obviously in the e-bundle, the courts were looking at the charging section, section 54, it's between D and D on that page of the Stamp Act 1891. Was it a conveyance on sale when an option was granted? And then, if you go to page 386...
Well, before that is the definition of conveyance on sale in section 54.384.
Yes.
So it's every instrument and every decree or order of the court whereby any property or any estate or interest in any property. So that's the definition there. It's different from ours.
It is, my lord.
Yeah.
And that's obviously why I bring it to
Yeah.
your attention. They're looking at a very different charging provision. But then going to page 386, start between B and F, Mr. Justice Brightman starts, leaving to one side for a moment the Miller case, there is a long line of authority which establishes that an option to purchase land creates contingent interest in land. The starting point is London and South Western Railway against GOM, which he goes through, and then D relies on the statements of the George Jessel, MR, which I took you to, and then at F, the judge goes through similar statements in later cases, and the Court of Appeal affirms that decision, and that's tab 17, page 63, page 67 in the e-bundle, and you can see it's page 66 of the paper copy, Lord Justice Russell, the judge, reference Mr. Justice Brightman, quite rightly on authority, which is what I've just taken to, how that section 54 is applicable in an appropriate case, though the instrument creates for the first time the property or the estate or interest in property, and as a general proposition, that is not challenged. And then, very finally, if I may, tab 18, next tab, page 71, 74 in the e-bundle, decision of Mr. Justice Hoffman, as he then was, Sparrow against Glen Crown Properties. And the relevant principle in this case was whether the grant of an option is interest in land and whether it's void unless in writing as required by Section 2 of the Law of Property Miscellaneous Provisions Act 1989. That's the context. But then you go to, if you would, page 77. Then the judge states, it's starting at C, here the underlying principles are clear enough. The granting of the option imposes no obligation on the purchaser and an obligation on the vendor, which is contingent on the exercise of the option. When the option is exercised, vendor and purchaser come under an obligation to perform as if they had concluded an ordinary contract of sale. And the analogy of an irrevocable offer is, as I have said, a useful way of describing the position of the purchaser between grant and exercise of the option. Thus, in J. Sainsbury against O'Connor, Millett J. used it to explain why the grantee of the option to buy shares did not become the beneficial owner until he had exercised the option. But the irrevocable offer metaphor has much less explanatory power in relation to the position of the vendor. The effect of the offer which the vendor has made is, from his point of view, so different that of an offer in its primary sense that the metaphor is of little assistance. Thus, in the famous passage in London and South Western Railway Co. against Gom, Sir George Jessel had no use for it in explaining why the grant of an option to buy land confers an interest in the land upon the grantee. And then he goes through the passage I referred you to a moment ago. And then if you go to page 80, last page of that tab, it follows that in my view, this is at G, it follows that in my view, the grant of the option was the only contract for the sale or other disposition of an interest in land within the meaning of the section, and the contract duly complied with the statutory requirements. Our case is that on the common law, the effect of the option at the time of grant is that it has bound, it has fettered Mr. Fanning's ability to dispose of the property. And I took the court to the option agreement, and you saw it's a real-world option agreement which was a fetter on Mr. Fanning's ability to dispose of the property. He could not, sorry.
Yeah, just to clarify, if I recall correctly, the option wasn't registered at the land registry, so it would have had an effect in contract.
My lady, exactly. It would have had an effect solely in contract, and Stanley On was free to, and is free to, rely on enforcing the contract in the court. But of course, the question then arises, if Mr. Fanning were to, in some way, seek to renege on the contract, the nature of the remedy available to Stanley On, potentially specific performance, because damages would not be an effective remedy in relation to property which is obviously unique and recognised as unique.
So you say it creates an equitable
My lady, yes.
interest.
That is our case. These are our submissions in relation to the nature of the legal interest which is granted through the option. If I could then turn to the stamp duty land tax regime, and I've taken the court to...
I'm sorry if this is a very basic question to land lawyers, but where you have an option and the option period starts in 5 years' time, what is the situation in the first 5 years?
It's an option which is enforceable in accordance with its terms, in our respectful submission, my lord. So whilst it can't be exercised until the point that the option period, the exercise option period opens up, it's still nonetheless.
No, but what if Mr. Fanning decided to sell it, is I think my lord's point, before the start of the option period. He wouldn't have to sell it to the company, San Leon. So can he sell it to me, to you?
In my respectful submission, no, because...
So you can't sell it to anyone for 5 years?
No. In our respectful submission, that's the effect of the judgment.
So if one, I mean, obviously one can play around with the facts, but let's suppose the option said that on a day certain 10 years hence, you have an option to purchase this property, and you can only exercise the option on that day. Either you do it or you don't. Does that mean that the property is simply frozen for 10 years?
My lord, yes, because that's the nature of the bargain, commercial bargain, that Mr. Fanning would have freely have entered into on your back pattern.
So, so for £100, he's sterilised his asset.
Yes, but equally, if it was £1 million, he would have sterilised his asset. But as a matter of contract law, and beyond contract law, because of the very special nature of land and the effect of granting an option based on the case law authorities.
But I haven't yet. I mean, I've understood your answer, which is that he can't sell it. But my question is, why can't he sell it?
Because he's given an equitable interest over the land in favour of San Leon, subject to the terms of the option agreement. So he's bound to himself.
Isn't he would be in breach of, you would say he'd be in breach of contract if he tried to sell, because he may be depriving.
Well, sorry to interrupt, but why is he in breach of what bit of the contract is he in breach of?
It's not an express term. You're saying there's an implied term that he won't dispose of it before the opportunity to arise. That's what I think you're saying.
My lord, yes.
So you have to rely on an implied term.
It's jolly difficult.
So that the net effect of this is that he has, to use the unattractive jargon, sterilised his asset in favour of somebody who may never take up their £100 rights at all.
But of course, it's a bargain that he, on your fat pattern, my lord, he's freely entered into.
What sort of bargain is that?
Well, it's a bargain that the First-tier Tribunal has decided they both mutually had an interest in entering into the option agreement, and he was free to sterilise the land on whatever terms he agreed with San Leon, which to you or I may not be regarded as an attractive proposition, but to Mr. Fanning and San Leon was attractive.
And what he gets is £250,000 less. He doesn't have to pay that to the tax authorities. He gets £100 from San Leon, so he can go out for dinner, and £250,000 saved because he doesn't have to pay that to the land revenue.
My lord, as I said...
But that's his choice.
My lord,
for us to express a view on that, or even raise a judicial eyebrow, it's up to him.
No, absolutely, my lord. And as I said at the outset, I make no bounds about the point that this was a stamp duty land tax savings scheme that he entered into.
Right. So, I'm sorry I interrupted you there, but we'd...
No, not at all.
We'd last touched on the authorities. I think we'd left those for you to articulate the principle about options.
Yes, I was going to turn directly to section.
Right, well now we're coming to the...
Get to the meat.
The meat, yes. It's been very helpful so far, thank you. Right, 45.
Section 45, which is tab 6, and I hope page 14 within everyone's bundle. So section 45, subsection 1. This section applies where A...
Well, do you want us to just carefully read to ourselves? I mean, how much would you like us to carefully read, and then you can comment?
I was going to, because section 45 is so pivotal, if...
Sorry, I saw there was a very long red line, and I was anxious to spare you from reading everything. So
yes, I was rather hoping to
comment.
If the law permit, if your lordship permits, to read through it, but also comment, seeking to hopefully apply the facts.
Very well.
Law as
Off you go.
45 subsection 1. This section applies where A contract for a land transaction, the original contract, so this is the vendor company and Fanning contract, is entered into under which the transaction is to be completed by a conveyance. So in our respectful submission, we were within A. B, there is an assignment, subsale or other transaction. Pausing there, other transaction, we say, granted the option is an other transaction.
But you don't know yet because you've got to read the rest of the definition.
My lord, yes.
You're hoping at this stage, aren't you?
I am,
Yeah.
and I'm guilty of commenting as I go through. relating to the whole or part of the subject matter of the original contract. And pausing there, on our case, the option relates to the whole of the property, which is subject to the original contract. As a result of which, a person other than the original purchaser becomes entitled to call for a conveyance to him. So, dealing with as a result of which, the effect of the option is that a person, San Leon, other than the original purchaser, Mr. Fanning, becomes entitled to call for a conveyance to San Leon.
But that's not the transaction. I mean, he becomes entitled to call for it if he exercises and gives notice. The option doesn't entitle him to call for the conveyance, it entitles him to exercise notice.
Another way of putting it might be that pursuant to the option, he may in future become, or possibly will in future become.
My lady, yes,
But there's a present tense, becomes entitled.
No, I recognise, but it's looking at restarting B. So the other transaction is the option.
Yes.
Clearly relates to the subject matter, which is the property. As a result of which, San Leon, not Mr. Fanning, becomes obviously looking to the future, becomes entitled to
Why
call
do you
for
say
a
that's
conveyance.
looking to the future?
Well, as a result of which a person becomes, it doesn't say has exercised the option, becomes entitled to call for a conveyance and under the, sorry my lord.
Are there two problems? This is to say, there was a land transaction within 44.1, but instead of it going to the two parties who are parties to that, the title goes to somebody else, becomes entitled. He'll get the conveyance rather than the person who would have got it under the original land transaction. But firstly, you don't get the title under the option, you get the right to give notice to call for it. And secondly, he will only become entitled after 2016 or whatever date it was. He can't become entitled for 5 years at least.
My lord, yes.
There are two separate problems, if
yes.
you follow me.
Well, those are the terms of the option, but on our case, the effect of the grant of the option is that San Leon, as grantee under the terms of the option, if it decides, well, point one.
If it waits for 5 years and then exercises the option, it can serve notice and become entitled at that stage.
Yes, my lord, but it has an equitable right from the time of grant in relation to the property, but not capable of being exercised until the start of year 5.
And not entitling him to call for the conveyance until at least 2016, and he gives the notice. Yeah.
On the terms of the option, I readily recognise that point.
Yeah.
I mean, it might be thought, we might be able to agree about this, that a paradigm case would be where there was a purchase transaction, number one, accompanied by an onward sale pursuant to an option transaction, number two, and that the standard transaction that would come within 1B of section 45 is that, namely, simultaneous or near simultaneous passings on of the interest in the property. Everybody's agreed that
yes,
that's
that's common ground in terms of the paradigm case, where you would have a sub-sale.
And that is a beneficent provision from the point of view of the first purchaser, who becomes the vendor, because it means that there's only one set of stamp duty.
Yes, and that's the purpose of the
That's the purpose of the subsection.
Precisely to make sure only one person in the chain pays stamp duty.
Exactly, but your submission is that it in fact has the consequence, well, no doubt it would be said unintended consequence, that no people potentially have the responsibility to pay stamp duty.
Well,
so something that intended to be beneficent turns out to have completely the opposite effect.
My lord, we say on the wording of the legislation is then enacted.
Right. So it notwithstanding thoughts like that,
Yes,
the wording compels a different outcome.
my lord, yes. And just to step back slightly in terms of what has been entered into by the parties, we respectfully submit that if San Leon exercises the option, it will pay stamp duty land tax at market value in relation to the property, and that is in accordance with the objective, the statutory purpose of the provision, because it's only one, is
Well,
last
if
person
it
in the
does,
chain.
if it does,
If nobody does,
But you can also
precisely.
describe that as a totally separate transaction, so of course it gives rise to SDLT.
If it's not exercised, I can well see the point that there has been a permanent deferral of stamp duty land tax.
and that doesn't seem to be what this is driving at. So the question is, which words in 45(1) or later says, in fact, you've got to interpret it that way? There is no way in which you can read the word becomes or the context, substituting A for B, that allows you to lead to a result where you pay the tax now, and of course, because the tax is paid then,
Yes. Might I continue through
Yes.
the
Yes.
section?
but there's nothing in 45(1), is there? There's no words that drive us to that.
No,
No, okay,
because 45(1) is solely looking at in what circumstances is it
the section
engaged.
applies, yeah.
So, if you were to be with me, as the FTT was below, to decide that the grant of the option was an interest in land and it was an other transaction, we would be through 45 subsection 1, and then we would be dealing with the following provisions. But just to finish off subsection 1 at the end, references in the following provisions of this section to a transfer of rights are to any such assignment, subsale or other transaction, and references to the transferor and transferee shall be read accordingly. So just to have that in mind. Subsection 1A, of course, is not in the legislation as enacted, and that came into effect by virtue of section 212 of Finance Act 2012 from the 21st of March 2012, and you will see that's the case because footnote 6 is replicated at page 16 of the Legal Authorities bundle. So that is the legislation which we discussed earlier about
So we have to ignore that,
Yes, precisely. Thank you.
because it's not a legitimate aid to statutory
Right, well, thank you.
interpretation.
Subsection 2, the transferee, so that would be San Leon, is not regarded as entering into a land transaction by reason of the transfer of rights. So it says, simply because there's a transfer of rights, it doesn't result in a land transaction. That's the effect of the opening part of subsection 2. But then it goes on to say that section 44, contract and conveyance, has effect in accordance with the following provisions of this section. So subsection 3 is key to the operation of, well, subsection 3, the first point is it's a deeming subsection. So we've got to go into the fictional world as per Fowler, which is required of us. So that section, section 44, applies as if there were a contract for a land transaction, a secondary contract under which, so we've got a secondary contract, which is a land transaction for section 44 purposes. A, the transferee is the purchaser, that's San Leon on our facts, and B, the consideration for the transaction is 1, so much of the consideration under the original contract, that's the vendor fanning contract, as is referable to the subject matter of the transfer of rights and is to be given directly or indirectly by the transferee, so that would be San Leon, or a person connected with him. And as the court will appreciate, the FTT found as a matter of law and fact, not challenged, that Mr. Fanning is not connected with San Leon. And we say, just pausing on the facts of this case, which the upper tribunal recognised being the case was that San Leon has given no consideration referable to the vendor planning contract under that original contract. And subsection 2, the consideration given for the transfer of rights. Well, the only consideration given for the transfer of rights is the £100 paid by San Leon on grant of the option. But I make the point again, whether it's £100 or £1 million, it's irrelevant.
What is the transfer of rights referred to here? I mean, I see how what was in the explanatory notes finds its way into the legislation, but what transfer of rights are we talking about?
And that takes us back to section 45(1) in terms of what is the transfer of rights. And we say the transfer of rights is 45 subsection 1. It's the other transaction.
So it's the cloak.
1B.
It's the tail, the last paragraph of subsection 1 tells you what the transfer
Yes,
of rights is.
my lady, thank you. Yes. References in the following provisions of this section, my lord.
That's I mean, I come back to the point I made before. It appears that what's being spoken of here is the same rights, whether it's the rights over a whole or part of the property, but the same package of rights, not a different package of
My
rights.
lord, that's absolutely correct, yes. It's not a different package of rights. The only package of rights that we have are obviously the rights created under the vendor fanning contract, and then the rights created by the grant.
But those are different rights, the rights under the option.
Yes, so two sets of rights. And we say that the set of rights that are engaged under section 45 are the rights relating to the option.
Yes, but my point, which may be misconceived, but I just want to be satisfied about it one way or the other, is that this isn't a transfer of rights because they're not the same rights.
Well,
It's entirely different
this
type of right.
this is the effect of the deeming in subsection 3, because we're going, once 45(1), assuming, if I may, that you accept that I'm within 45(1), that then takes us into 45(2). San Leon doesn't enter into any land transaction simply by entering into the option agreement, but it's section 45(3). It's the deeming provision which creates a land transaction.
Section 2 also begs the question because it refers to the transfer of rights. This is designed to protect Mr. Fanning, in this case,
If one gave
from incurring tax when he's in effect not benefiting from the rights.
my lord, in our respectful submission, and I hesitate to disagree, but where it says end of subsection 1, references in the following provisions of this section to a transfer of rights are to any such assignment, subsale, or other transaction. So the transfer of rights.
It's got to be that it's still those assignments, subsale, or other transactions have got to be in relation to those rights. It's not.
In our respectful submissions,
Sorry?
it
can't be satisfied if it's a completely different set of rights.
No, well, what it's referring to in our respectful submission, what it's looking at within the provisions when it's referring to transfer of rights is that it builds off what is the other transaction that the.
I think you may be trying to say that the transfer of rights, in quotes, is a defined term covering any assignment, subsale, or other transaction.
My
and
lady,
I think you will be saying that it shouldn't be read into any further than that.
my lady, yes, and if I had expressed it.
But regrettably, I've got a different problem. You seem to be reading 45(1) in total isolation and saying, is this another land transaction? Is this another transaction within 45(1)? I look at the words in 45(3) as part of a section, indeed part of a set of sections, which might throw light on other transaction, whether it is as broad as you say. And it seems to me, firstly, the word consideration, it's really looking at the amount of money that you pay for the land. So if it is only the £100, not the value of the lease, that makes me think, I do wonder whether the transaction was meant to include the option. And then you get on to my Lord's point, given that what is being the subject of the thing is so very different from the substitution of one person in the context of the sale, the original sale, do those two bits, the consideration and the transfer of rights, throw any light on 45.1 and the words other transaction, rather than saying, I've taken you to separate things that show it's land, an interest in land, and therefore I'm working everything else through as if it were a thing. I haven't made that clear, but I'm saying it helps you, it illuminates what transaction is.
Yes.
It's not something that you work out following on from an isolated assumption that it's a land transaction.
Yes, but if you accept our case is transfer of rights within the tail end of subsection 1, it's a definition.
Yes.
And within the definition, it includes the other transaction, which is the grant.
Yeah,
the option.
but if I use it to look at what other transaction means, and certainly if I look at consideration, when the rights are so very different from the original contract, and when the consideration is so very different, that makes me think whether other transaction is really related simply to a substituted sale, or to an option which may lead to a later sale in many years' time,
But
or no sale at all.
in my respectful submission, the effect of section 45.3 as a deeming provision is that we have to go, if I can use the term, go down the rabbit hole required by section 45.3 into the fictional world which is created by it. And it is 45.3, if I work my way through the subsection, and it's that world which we have to look at, which is constructed by subsection 3.
Can I clarify one point, which is, I may have picked this up wrongly from your skeleton argument. Are you saying that the option is the secondary contract?
Yes.
Yes. Must be.
Okay.
Yes.
Rather than a deemed contract with the characteristics set out in subsection
It is a
3.
deemed secondary contract.
Well, but you're
In my
it's not
respectful
quite the
submission.
same thing, is it?
No,
You're
it's-
saying that the
it's not.
option is a deemed
Yes.
secondary contract, whereas subsection 3 appears to deem there to be a contract
Yes, absolutely.
with the characteristics
Yes, my lady. Yes.
set out.
Yes. That's what I intended to say in my skeleton argument. And it's what we do say, and we said below, that the grant of the option through subsection 3 is the secondary contract, because that section, so section 44 applies as if there were a contract for a land transaction. Now, I flagged one point here, which is, of course, I say of course, in tab 8, which I'll come to in a moment, page 18, section 46, there's a specific provision which deals with the effect of granting an option, and it says grant of an option is a land transaction, but nothing in section 46 affects what is in other parts of the legislation, but I need to come back to that. But focusing in solely on subsection 3, I say that the option is a deemed land transaction, and it is the secondary contract within subsection 3, and what gets me there is 3A, and this is the fictional world we have to be in. The transferee is the purchaser, it's San Leon. The consideration for the transaction, the fictional transaction, is B1. So much of the consideration under the original vendor-fanning contract as is referable to the subject matter, answer nil. And 2, the consideration given for the transfer of rights. And transfer of rights on our case go back to end of section 45 subsection 1, where it refers to transfer of rights. That's a definition phrase, and it includes the other transaction. But the effect of subsection 3 is that it's rooting itself, for some purposes in the fictional world, in relation to what is the transfer of rights in relation to the consideration. So under subsection B1, so much of the consideration under the original contract is referable to the subject matter of the transfer of rights and is to be given by the transferee, or there was none given under the option agreement or otherwise, and B, the consideration given for the transfer of rights, which was the £100. Assuming, I accept a big assumption, I've got through that, it then goes on to say the substantial performance or completion of the original contract, which on our facts is the vendor company Fanning contract, at the same time as and in connection with the substantial performance or completion of the secondary contract, which is the fictional secondary contract, Fanning San Leon, shall be disregarded. So the effect is that the vendor company and Fanning contract is disregarded, so no SDLT payable by Mr. Fanning, and then you have to look through to substantial performance or completion of the secondary contract, and if you accept that the option is the secondary contract under the fiction created by section 45.3, then the effect then, going back to section 44, and it would be 44.4, page 11, is that there has been substantial performance of the secondary contract, which is the payment of the £100.
Okay, so you rely specifically on substantial performance of the secondary contract in terms of paying consideration.
My lady, yes.
So if I've understood it correctly, you disregard the first conveyance, the first sale, the substantial performance of the original contract, the handing over of the land and the payment of the 5 million. You ignore that.
My lord, yes.
Because there's been substantial performance of another arrangement, which you say is a deemed land transaction described as a secondary contract, namely the payment of £100 for the ability to exercise the option and call for a right of a conveyance.
Which falls in the nil rate band.
Yeah. So that's what. So it's these performance of, and I don't get any help. I'm wrong because I've gone down a rabbit hole, clutching Alice in Wonderland. I'm wrong to think of this as throwing further light on the meaning of other transaction, and it's assuming that the substantial performance is broadly going to be the same. You disregard the sale of the land under the original contract because you're charging the sale of the land under the secondary contract. You say, no, that's not at all what Alice is doing. Here, it's intended to say if you do have a secondary contract and it's an option for £100, the exercise of that means you disregard the value of the original land transaction. That's how it works in your analysis, the rabbit hole that you've described.
SDLT becomes payable when San Leon exercises the option at market value.
But we're looking at this section
My lord, yes.
only at the reason why Fanning doesn't
Yes.
pay rather than why,
My lord,
say,
yes.
Unlon may pay. And the reason why Mr. Fanning doesn't pay, after he substantially completed the contract, paid 5.2 million and got the flat, is because at the same time there is substantial performance of a different type of contract, the grant of an option for £100. And that is what was
My lord, yes.
what the clause is intended to permit and drive towards.
Yes, and that was the nub of the planning, and in my respectful submission,
Perfectly acceptable.
that is
If that's what the words mean, that's what they mean.
Mr. Hick, can I ask one question as well? What's been described as the tail piece of subsection 3 talks about substantial performance or completion at the same time as and in connection with. I don't think there's been any debate that I've seen over this, but what do you say about what those words do and how they apply on your...
It's common ground. Both the contract and the option were entered into on the same day.
Yes, that's
And
not the bit I'm focusing on.
And in
I'm
connection.
focusing on the words "and in connection with." It's not just at the same time.
Yes. So, in relation to the substantial performance or completion of the original contract, it's obviously the vendor-fanning contract, at the same time as, and in connection with, the substantial performance or completion of the secondary contract, which on our case is the grant of the option. And we say, from a timing perspective, one, all happened on the same day, and the option would not have been granted other than in contemplation of the steps of the planning that had been implemented. So the steps, so everything that occurred on, I think it was the 16th of September 2011, formed part of a tax planning.
But they're different people. You've told
scheme.
us all along that San Leon is separate. They want to own the flat. They want to be able to rent the flat to their employees, and that they're entirely separate. So how are they connected with? At the moment, they simply happen on the same day, and one of the three people involved is the same person. But the sale would go ahead as far as Glencore is concerned, whether or not there's an option.
My lord, yes, but the words in that paragraph don't require the contract and the secondary contract to be between the same parties.
No, but it's got to be in connection with, and it's less likely to be in connection with if it's completely different people performing transactions for completely different purposes. And the sale of the land by Glencore has got nothing to do with the option.
That's, in terms of matter of fact, that's never been the subject of challenge in the first-tier tribunal. And obviously that was a matter which was open to be perceived.
Right, so it's a new point.
It's a new point.
Well, but I raise it because what we're trying to do is interpret Section 45 to see whether it applies to this sort of transaction, and I just wonder whether it gives us any clue.
So I'm just going back to the first-tier tribunal decision. I'm just looking for a passage that deals with this point, but so I'll try and do it quickly. I'm conscious of the fact. Could I ask my junior to look for the passage? So. Sorry.
It seems to be. I'm still in the FTT. Would it be paragraph 41?
My lord, thank you. Secondly, so this is core bundle tab 7, page 67. Hopefully those page numbers match what you have. Secondly, alternatively, while relief under section 45 does not require the secondary contract to be completed by an actual conveyance because section 44 provides the alternative of substantial performance, the relief is dependent on the original contract being substantially performed or completed at the same time and in connection with the substantial performance or completion of the secondary contract. Therefore, section 43B1 could be read to refer to the consideration given by San Leon on completion of the original contract, nil, as Mr. Cannon suggests. Section 45.3b2 should then be read as referring to the consideration payable on substantial performance of the other transaction in section 45b1 in conformity with its terms as a result of which San Leon is in possession to call. So I was just reading down.
Right, these are from Ms. Wilson's submissions.
No, that's not the point I have in
No,
mind.
this is a slightly different point. This is what the consideration 45.3.2 means. It's not dealing with the tailpiece, is it?
My lord, sorry.
That's dealing with the meaning of consideration
Yes,
in 45.3.2. It's not dealing with the tailpiece and the in connection there.
But there is, unless my memory is deceiving me, there's a point in here in terms of it occurring at the same time, which is what I was inviting my junior to look at. If you're content for me to move forward and then come back. Sorry, I can't find the point. Sorry, 23 is obviously the point, page 64, about it being the other transaction. Then, paragraph 29, the tailpiece of section 45.3 provides relief by disregarding the original contract for SDLT purposes if the substantial performance or completion of the original contract is at the same time as and in connection with the substantial performance or completion of the secondary contract. There is no dispute that the original contract, the sale to Mr. Fanning, completed on the 16th of September 2011. The question of the effective date of completion of the secondary contract is key to the availability of relief.
Then it goes on to whether you include in the consideration the whole of the amount of the value of the property. It doesn't seem to have looked at the words "and in connection."
Yeah,
No.
that was my recollection,
Yeah.
that it hadn't been,
No.
it wasn't the focus of debate, which is why I wanted to flag it, whether it assists in the interpretation.
Could I ask a different point before you move on? That where you're looking at the tailpiece,
My lord, yes.
you contend that there was substantial performance or completion of the secondary contract, namely the option. What has substantial performance got to do with that? I thought substantial performance was effectively to deal with the
Payment.
the subject, the contract, but not completed. So why does substantial performance
Come into it.
bite on the creation of an option?
So it bites on the creation, the option, only in circumstances where you've gone into the fictional world created by section.
But it wasn't substantially performed, it was performed.
Well,
According to
that's right.
this, or why was it not completed?
Well,
Why are we concerned with substantial performance?
Well, because if you go to section 44, subsection 5, a contract is substantially performed when a substantial amount of the consideration is paid, but then 44.7, for the purposes of subsection 5b, a substantial amount of consideration is paid or provided if none of the consideration is rent where the whole or substantially the whole of the consideration is paid. So all the considerations paid, and within the world of the SDLT code, I meet the condition in my respectful submission within 44.7a.
Okay.
So it is completed. It's not substantial performance, the option contract.
Well, within the world of section 44, it's been substantially performed.
Yes. But the question is whether any light is shone by these provisions, which seem to have a rather different genesis.
Yeah, because
In other words, whether you can take advantage of them by referring back to definition sections.
well, my lord, thank you, because section 45 subsection 2 tells us I can, in my respectful submission, because it says the transfer is not regarded as entering into a land transaction by reason of transfer of the rights, but section 44, contract conveyance, has effect in accordance with the following provisions of this section. So once we've gone down into the fictional world created by section 45.3 as to what is the secondary contract, we then have to take that fictional world, which continues in terms of the construction of section 44. And at that point, I say the secondary contract falls within section 44, subsection 4, and that enables me to then rely on 44, subsection 7, because I'm within A, all the considerations to be paid, whether it's £100 or £1 million.
Right.
That is the heart
Yeah.
of the tax plan, the SDLT planning that was entered into. And for completeness, in relation to these sections, if I could take them to tab 8.
I hadn't appreciated this point, but why aren't you in 44.3? The transaction has been completed, the secondary contract.
44.3. If the page 11, if the transaction is completed without previously having been substantially performed, the contract and the transaction effected on completion are treated as parts of a single land transaction. In this case, the effective date of the transaction is the date of completion, and in terms of completion, that is, well, looking at section 44.10, references to completion are to completion of the land transaction proposed between the same parties in substantial conformity with the contract. I absolutely take and...
Because if you're right, and the land contract is the option, and you put the option into 44
yes.
and you apply 44,
My lord, yes.
then it's been completed. It doesn't matter, you say, but I don't see why you're in 44
No, my
and
lord,
7.
yes.
I think you're in 43,
Yes.
44, 3 and 10, but it doesn't matter.
Yes, no, with respect, I gratefully adopt your reasoning, my lord.
Well, I don't know anything about tax, so I wouldn't if I were you.
No, but that is, on the face of it, that is yet another reason as to why, in the fictional world, if you accept that that's the consequence of the fictional world, that as soon as £100 has been paid, then on the grant of the option, then it's completed that option agreement. For completeness, I should go to section 46, page 18, tab 8, which is options and rights of preemption, which is subsection 1, the acquisition of an option binding the grantor, Mr. Fanning, to enter into a land transaction is a land transaction distinct from any land transaction resulting from the exercise of the option or right. So at this point in the code, it makes a distinction between grant and exercise. Subsection 2, the reference in subsection 1A to an option binding the grantor to enter into a land transaction includes an option requiring the grantor either to enter into a land transaction or to discharge his obligations under the option in some other way. And then finally, subsection 3, the effective date of the transaction in the case of the acquisition of an option or right, such as is mentioned in subsection 1, is when the option or right is acquired, as opposed to when it becomes exercisable. So from the perspective of the code itself, it makes a distinction between grant and exercise, and grant is itself a land transaction, but also to draw to your attention, subsection 4, nothing in this section applies to so much of an option as constitutes or forms part of a land transaction apart from this section.
But it can't be a land transaction within 44 of itself, just looking at 46, could it? Because that wouldn't be a land transaction to be completed by a conveyance.
My lord, yes, you
That's
need
the
section
reason why.
45.3 in the fictional world.
Otherwise you couldn't get into it, yes.
My lord, yes.
So what's the purpose of 46 then? Why is it there? What does it do?
Well, yes, it replicates Wimpy in the Wimpy, which created a charge to stamp duty. So.
Oh, I see. Just when you grant the option, you've got stamp duty
Yes.
on the grant of the
So
option.
if there's a valuable option program,
It makes it clear.
if there was an option for £2 million, then you'd do them for stamp
pay
duty on that.
SDLT
Yeah.
on it. And so effectively on one view, perhaps stands the
Okay.
avoidance provision. Those are our submissions in relation to what the law is properly construed in relation to, one, whether there was an other transaction created in relation to the grant. Second, if you accept that there was another transaction within section 45.1, and we have, on our case, gone through to section 45.3 in the fictional world, and you accept the secondary contract relating to the grant of the option, we say within section 45.3 Roman 2 that the only consideration is the £100. There's no basis for ascribing market value or any other consideration because San Leon and Mr. Fanning were not connected. We then say that it was substantially performed because the payment of £100, or taking my lord's point, it's been completed because of the payment those are our submissions. I'm deeply conscious of two things. One, time. The second is that I haven't taken you through the passages in the upper tribunal where we say there are errors of law, but I have done that in, I hope, in our skeleton argument.
Can we just identify your paragraphs of that, and so that they're safely...
My lord, yes, if I find my core bundle, which is hiding behind me.
Tab 13, I think.
So that is at tab 13, and in terms of our grounds, that all starts at yes, so that starts at page 129.
Yes.
Under what was ground 2, and under that heading we set out from where is it? The basis of the submissions which I've been through in terms of the law. And in
It's
terms
really
of,
paragraph 25 to the end.
yes, precisely. I can take you through the passages.
No, but if I think what would be helpful is just if there are any particular points you want to alight on within that section, but by all means do. But otherwise, I mean, they have been read and they will be read.
Great, thank you. And in relation to ground 3, in relation to the £100, you have our submissions. Those are paragraphs 40 through to 45, and we've given the various references in the upper tribunal decision at paragraph 43, 44, and then working through all the reasons, paragraph 44.4, where we deal with various aspects of the upper tribunal decision on those points, and then on the final ground of appeal relating to substantial performance, again, it's for all the reasons set out between paragraphs 46 through to 51. We were never granted permission to appeal in relation to section 75A because the upper tribunal decided we failed on all the non-75A points and didn't reach any conclusion on 75A. As I said, paragraph 52, well, paragraph 52 of our skeleton, page 139. From the appellant's perspective, 75A is not before you, but HMRC has filed a respondent's notice.
Yes.
In our respectful submission, assuming this court is with the appellant, we would invite the court to remit this matter back to the upper tribunal for it to then reach a decision on the basis of full argument on 75.
But you're going to have the chance to respond to any proper point made on the respondent's notice.
My lord, yes. To make a further point, which we did identify our skeleton to the Court of Appeal, if it goes back to the upper tribunal, then from Mr. Fanning's perspective, whilst we go down to the upper tribunal, depending on whichever way the decision goes, then obviously we have an appeal potential. Either party has a potential appeal right then back into the Court of Appeal. So it's preservation of any rights of appeal in terms of remitting it back on 75A. Of course, if the court would like me to engage on 75A, and this is the reason the court bundle was updated, we do have our skeleton argument, which is before the upper tribunal, at tab 15.
Right, that's why you referred to it at the beginning, was it?
Yes. And at paragraph 57 through to paragraph 68, which is pages 183 to 188, we do set out our submissions on 75A. Just standing back, if one accepts that planning has been valid up to the point of 75A and therefore within the statutory purpose of the provisions, the effect of 75A applying would be that a charge would be imposed on Mr. Fanning, but if the option is subsequently exercised by San Leon, you'll then have a second SDLT charge. So effectively, you'd have two SDLT charges in the context of a planning arrangement which has been accepted to be operative in relation to Section 45, the subsale rules, because the purpose of Section 45 is that there's only one SDLT charge running through that chain. And if we are truly within Section 45, in this court's view, the effect of Section 75A creates a very real and material risk of two SDLT charges. So it's completely at odds with the legislative purpose of 44-45, seeing we've gone through it. But the nub of our argument in relation to 75A, in a nutshell, is that in applying 75A, you have to look at what the scheme transactions are. And at the heart of it, we say, as we did in the First-tier Tribunal, that you have to wait until exercise of the option to find out whether or not any SDLT has been saved. And until that has occurred, you can't test whether or not there has been any SDLT saving of such a nature which is regarded as being sufficiently, wrong phrase, being of the wrong type of planning that 75A bites and imposes a charge on Mr. Fanning. But I'm conscious of the fact that that's obviously not a substitute for taking you through the sections. I'm in your hands as to where you'd like to do that.
No, that's been extremely helpful. Thank you, Mr. Hickey. Yes, Ms. Wilson.
Thank you. Could I just give myself a
Yes, please.
support? So I will. So we'll go back in time. What I'd like to do is begin with section 44, and then move on to section 46, and then come back to section 45. And I do it in that order because essentially we've got two contracts in this case. There's a contract between Mr. Fanning and Glendale Enterprises. It's a perfectly ordinary contract to buy a garden flat in Grosvenor Square. Small or no deposit in it completed for £5 million. And then there's the option. And we're looking at an option grant only. Obviously, there's been no exercise. Both, in fact, would fall under the general rule for charging SDLT because on their face there's an acquisition of a chargeable interest. But in fact, in the code, we've got a specific rule for the first contract, which is section 44. And there's a specific rule for the option, which is section 46. And so I'd like to take the court to those. And I say that's the end of it in this case. They're the two provisions that give the correct tax treatment. And so I'll explain why, in light of those two provisions, section 45 doesn't apply. So section 44, if I could ask the court to turn to it, which is at tab 5, the authorities bundle. And you've seen this. It applies, subsection 1 is important, obviously. It says it applies where a contract for a land transaction, so that's the acquisition of a chargeable interest, such as a leasehold or freehold, is entered into under which the transaction is to be completed by a conveyance. And that's the shape, if you like, of the transaction, the first contract between Mr. Fanning and Glendale. Had Mr. Fanning not called for a conveyance, Glendale could have forced him to take the conveyance. the deal, the transaction was that it was to be completed by conveyance. Nothing else, not a sale of an equitable interest or anything of that nature. And as it happens, because it was a simple contract to complete, it fell within subsection 3. The effective date was completion 16th September, and it's treated as a single land transaction, and that's very straightforward, ignoring, of course, the option for the time being. Now, I wanted to make just a few points about section 44 more widely, because it feeds into what I'll come to say about section 45. And section 44 is very important to section 45, because section 45, its job is to modify 44. So it creates that secondary contract where it applies, which is a deemed contract. It's a deemed contract for a land transaction. So it doesn't matter that the deemed secondary contract with our deemed purchaser and deemed consideration it is notional and might be of any shape, if you like, because you've got a contract within section 44, you might have an assignment or a declaration of trust. It deems there to be a contract which fits within 44.1. And that's why it says it's a secondary contract. It's a contract for our land transaction. So it creates a contract to which 44 can apply. Now, the first point I just wanted to emphasise, which I've really done, is those words "is to be completed in one." There is in the bundle a case, Peter Bones. So it's an old stamp duty case, which was actually a failed vesting in contract scheme. And I just wanted to take the court to it briefly, simply because there, Mr. Justice Weinlott just really gives the sort of describes in a nutshell the kind of contract with which, in fact, section 44 would be concerned. And Peter Bone is at tab 19. And so it was a stamp duty scheme, and the question was whether there was a successful vesting contract scheme. The revenue challenged it on the basis that it wasn't actually, in our SDLT terms, a contract which will be completed by conveyance. It was just a sale of an equitable interest on a proper construction of the contracts. The parties had just agreed to sell the equitable interest. So there was no possibility of vesting in contract. A sale of an equitable interest was liable to stamp duty. That was the issue. And so the court construes the contract before it to see, well, what kind of contract is this? And just at page 929 of the decision itself, which electronically might be page 93, if you add full,
Other way.
or 89, if you don't have it. But it should be page 99 of the judgment.
Oh, hang on. No,
But the
we've got
judgments are in the 900s.
we've got a different
So
set of law
tab
reports.
19, I've got a printed page 89
No.
of the actual fund.
Well, we need 90.
Okay, well, we've
It's
got
the
that.
last page of the case, last but one page.
Yes, it's page 93 electronically. I think that.
89, yeah.
So we're on page 89, are we going?
Yes, thank you. And so what the court is doing, just on the first page where it begins, bottom paragraph J, the case for the appellant company. And then it goes through the appellant company's argument as to why this contract is in fact an executory contract pending conveyance. In other words, a contract which will be or is to be completed by conveyance. And the court rejects the argument, construing the relevant clause was a clause 4.1. And starting at C, or just above, it said, so on completion of the agreement, the vendors were constituted nominees or bare trustees of the property. They did not remain constructive trustees under an uncompleted contract which was capable of being specifically formed. There was no longer any contractual obligation which remained to be performed. This is clear from 4.4. The vendors as trustees are to execute such assignments, transfers and conveyances of the property to such personal purchases as the purchaser may require. So that's rather like the purchaser has an option to call for the conveyance, but that's all. They do not have the right, which a vendor under an uncompleted contract has, to require the purchaser to take a conveyance and so relieve him of a potentially burdensome legal title. I think that strictly the agreement operated as a transfer of an equitable estate in the freehold property and not an agreement for the sale of the equitable estate. Well, that was which stamp duty charges.
I don't understand this yet, and I don't understand how it's helping us, because this is section 54, and whether that particular deed or contract fell within those very broad words of 54. What am I getting out of it for this case?
I was just wanting to make the point about what is the focus of a 44.1 section 44 contract, and it's a contract which is to be completed by a conveyance.
Well,
it's not an option.
44.
It's not the sale of an equitable interest. It's a contract where there's, as Mrs. Justice Matthews described it in where there's a difference in time between entering into the contract and completing it. That's the nature of the...
So you've got to remember the last 6 words of section 44.1 then.
Yeah. You may be helped by the explanatory notes. I think we went to this earlier for what is now section 44 referred specifically to resting in contract.
Yes, and that's the second element of 44, which is it doesn't block it, but it prevents that kind of planning being available in stamp duty, and it does that with the concept of substantial performance. So if you pay all the price, or you've got the right to go in, and all you do is just fail to complete because you might have a very long completion date, you nevertheless trigger liability to SDLT, because in truth you've acquired all your the property rights that you set out to acquire. And the important point about that is that that demonstrates something about SDLT and section 44, which is it's very much about identifying the underlying transaction and taxing it. You identify the substantive transaction. And it's not very much so, not like stamp duty, which can artificially be avoided by tricks with conveyancing. You identify the real acquisition of the property, and if there's a large amount of consideration, you'd expect an SDLT charge to rise. And that's what section 44 does with its concept of substantial performance. And it's not punitive. If you substantially perform, that's a land transaction. You must return it, and you'll pay the SDLT on the consideration. If you then go on and complete, that is then said to be another land transaction. But there's no question that you then pay SDLT on the total amount again. You pay the right amount of SDLT for the total transaction. So it's about trying to identify the right amount of SDLT on the consideration. Not punitive, but it's not an exemption. It's not a relief. And as I go and explain, if you're applying or reading section 45, so it modifies section 44 to relieve what appears to be the very clear substantive land transaction, which is the acquisition of a leasehold for £5 million, which Mr. Fanning can then go in and enjoy and let out and enjoy the rents and so on. And he's even got the legal title in his name. If you look at the land registry, you see that he owns the legal title. Something's really gone very wrong with how you're reading section 45, because section 45 is supposed to modify 44, not turn what is essentially a charging provision on a substantive land transaction into an exemption or a relief.
Into a what?
An exemption or a relief. And so that, if at the end of the day, as the upper tribunal held, that's the provision that applies to the original contract, that produces a sensible and coherent result. And then as to the option, what I say is it's dealt with specifically by section 46. That's the guidance that we're given from the Act on how to deal with that. And as the court's aware, that preempted the point I was going to make. Section 46, it's described in the explanatory notes as an anti-avoidance provision. And the problem in old stamp duty was that, as my lady, Lady Justice Falk has said, is that you would front load the consideration into an option and you simply wouldn't stamp it. And unless you stamped it, or produced the document for stamping, you didn't pay the stamp duty. And then you'd have a much lower consideration on the actual contract for sale. That you wouldn't think that would work in any event for SDLT, but Section 46 just makes that absolutely clear. And Section 46 shows that for SDLT, it's adopting, or the relevant analysis of an option is that which you find in Wimpy. And I want to take the the court, if I can, to that case. The Court of Appeal decision is at tab 17. And the first passage is at hard copy page 66. Capital E at the bottom. I'm not sure if you have to add the 4.
We do.
Page 66.
So possibly plus 4. It should be page 998 of the judgment.
Yes. You're looking at the bit
Which
that
bit?
isn't sidelined. Is that it? You're looking at the bottom.
No, so this is in. Yes, that's right. It's at E at the bottom.
Right. So
I think it's H actually.
H.
Oh, H. I'm
Yes,
sorry.
it's an H.
That's like a.
Right. So the red bit is just
The optician's test. Yes.
red bit is throws off the scent. Yes.
I'm very sorry about that. Yes.
Right.
Yeah. So Inland Revenue Commissioners in Angus. And so there's an argument's been put about the Angus case. The court says it was a case of a purely executory contract for the sale of property, a contract which would be specifically enforceable, but it was not a transaction of sale complete in itself, as in the present case in relation to the subject matter in the present case, namely the option. So there the court's analysing an option as a transaction of sale complete in itself, but the subject matter is the option or the option grant. And of course that's the equitable interest that you sell when you grant the option. And then at the last sentence, in the present case we have an executed transaction which the subject matter was the granted option. So the analysis is a transaction of sale complete in itself. That's the option grant. And the same point is made again over the page at C. Naturally, I do not rely on that fact as indicating that Corey's case supports the view I formed, but the phrase that was used by Lord Reed, namely that the instrument was not an agreement to sell anything, is literally quite accurate. Because in fact, it was in fact the sale of something and not an agreement thereafter to sell. The taxpayer company in the present case gains no support from that phrase for its contention that the option instrument now before us is not to be regarded as the sale of the option. And then finally, just again over the page, Lord Justice Stamp, I agree. I would at the outset emphasise it's no part of the Crown's case. The instrument is an agreement for sale or operates as a conveyance on sale of Mr. Morgan's land. That's the underlying land in respect to which the option is granted. Clearly it's not. And that's just making the simple point that in this analysis, the option grant is complete in itself. And that's then what you find if you turn what to do to section 46, which is at tab 8. And it says to like effect the acquisition of an option binding the grantor to enter into a land transaction is a land transaction distinct from any land transaction resulting from the exercise of option. So that's making clear that the grant of the option itself is the acquisition of a chargeable interest. What's being sold or acquired is the equitable interest, which is the option. And that's it. That's the relevant transaction for SDLT. Here, the fee was £100. It's under the threshold, so no SDLT was due. But if it had been £300,000, it should have been returned in an amount of SDLT paid. And it fits comfortably or in a coherent scheme with the original contract also being chargeable under section 44, because it's doing something very different. It's granting this or selling a very different interest, which is the option. And for SDLT, that's dealt with my submission under section 46. 46 makes that clear. And just a final point on that is that there's nothing in the Wimpy case or in any of the other authorities that my learned friend took you to, which means that just because the grant of an option is a distinct land transaction under 46, or a transaction distinct in itself as a matter of general law, nothing in that means it's somehow not very fundamentally a contingent right to call. So not a present right, but a right contingent on exercise of the option, and typically on a future date. In fact, that's very much why the equitable interest that is sold is the equitable interest that it's sold. It's inherent in the right. So to the extent, perhaps more in my learned friend's skeleton than his oral submissions today, he relies on section 46 to say, section 46 deems the option to be something that's relevant to section 45. I say, well, I don't see that on the face of section 46, and there's nothing in the case law that tells you that it's anything other than a contingent right. So then turning to section 45, we see, just to make the point up front, that this section, its job is to modify 44. It's not some kind of standalone exemption or relief. And so it should work with or with the grain of section 44. It shouldn't fundamentally change the policy underpinning section 44. And we see that because it applies 45(1)(a), where there's a contract for a land transaction, the original contract is entered into, under which the transaction is to be completed by a conveyance. That is the contract that you have to be within 44(1). So it begins with a contract which is within section 44(1). And then the same point is made in subsection 2. How it works is it takes, in respect of the transfer of rights and the transferee, it creates a secondary contract to which section 44 is then applied. So it's creating a contract for a land transaction to which 44 can apply. Before making specific points on the construction of section 45, which I say fits the policy, the clear policy behind 45, I just wanted to take the court to the case St Matthews West, which is the judicial review, because there the administrative court and then the Court of Appeal, briefly sort of adopting what the administrative courts say, set out the understood policy of section 45. And it's consistent with, and they in fact referred to the explanatory notes, which the court's already seen. And so the first decision is Authorities tab 24. Beginning at paragraph 8. I'm not sure whether the court has any memory or recollection of the judicial review cases in this area. The revenue or the Parliament blocked. There were a huge number of subsale schemes in all sorts of variant forms, all relying on Section 45. The government challenged and the litigation began. But of course, while that's all progressing, they then blocked by statutory amendment the schemes as they came to know of them. So we see that in 2012 they blocked option schemes of this kind. There was another scheme which is considered in this case, which relied not on the grant of an option, but an agreement to grant an option. That wasn't blocked or covered by the specific amendment. Either the revenue didn't know about it, or they didn't imagine that anyone would think that that might work. But whatever the reason, it wasn't blocked. There was then a retrospective amendment to the legislation with effect from the date of the press release, blocking the scheme retrospectively. There was then a challenge to the validity of that retrospective amendment. And it's in that context that the court looks at. But I'm very clear, doesn't decide the scheme itself, but does look at the scope and purpose of Section 45. And so starting at paragraph 7 of the decision, so this is the administrative court, sets out the background to SDLT introducing an entirely new regime. Intended not to be something that can easily be avoided. At 8, particularly worth noting, the new regime focused instead on the substantive underlying transactions. And then there's a summary of section 42 and 43. Paragraph 9, section 44 contains detailed provisions setting out at the point at which a land transaction is treated as being entered into, in circumstances where there's a difference in time between entry into the contract and completion. But then at 10, the shift in focus to substantive transactions gave rise to a risk that SDLT will be paid twice in circumstances in which A contracts to sell land to B, and prior to completion there's a subsale, assignment or other transaction which results in a third party C becoming entitled to acquire all or part of the land at completion. This scenario occurs, for example, and then there's an off-plan example. 11, the original proposal was actually that they would both be charged. I would just make a sort of, it's as much an observation as anything else, because I don't suggest that this court should construe section 45 by reference to its original enactment. But it is worth noting that as originally enacted, section 45 was actually only a charging provision. And
sorry, I don't think you mean as originally enacted. I think
sorry,
you mean
not enacted.
Before the report
in the bill,
stage,
yes, I
in the original bill,
yes,
it was a charging provision.
And I don't suggest that we're construing the current section 45 or as enacted by reference to that. But what you did have in the original bill as drafted was a section 45 which was only a charging section, whereas at present it can be a charging or it can be a relieving section. And then that was followed by section 46, which was a charging provision for options, rather suggesting that section 45 dealt with subsales and similar, but not options. 46 deals with options. You wouldn't have two charging.
I mean, I thought that's where you were leading to, but is that right? 46 makes it clear that the grant of an option is subject to tax, like Wimpy, and therefore we know that. But does it tell us anything one way or the other about the meaning of other transaction in 45?
It could be that the amendments mean that it does apply. But I just really wanted to briefly just to note that you have these consecutive provisions, and one deals with how you analyse for SDLT something in the nature of subsale, and then the next provision is how you analyse for the purposes of SDLT.
So you're not submitting that the existence of section 46 means that section 45 cannot apply to options. There will be other reasons why.
No, but in the broader picture of Part 4 of 2000 of the Finance Act,
Right.
it's not irrelevant. And so then at 11, and perhaps I could ask the court just to read 11, and then you'll see she sets out the explanatory note to which you've already been taken.
Yes.
And the key words there are that that the policy problem is the fairness of double tax, where the intermediary acquires no lasting interest in the property, and functionally there's only one transaction. And then the same point is made in a different way at paragraph 12. The aim of what became section 45 was to place the taxation burden on the person who's going to have the use and enjoyment of the property. And then again at 14, there then follows a series of complex provisions designed to afford tax relief to someone who is no more than a fleeting interest. And that's endorsed by the Court of Appeal, so tab 25, paragraph 7. So again, the aim was to place the burden of SDLT on the person who was to acquire the use and enjoyment of the property in question, and reduce that burden on those with only a transient interest in the property. So I say that's
Give the paragraph number again, please.
7, paragraph 7.
Sort of goes over to the top of the page.
What page number?
Page 199
Thank
has
you.
got most of it on the electronic at the top of the
Thank you.
page.
So as a matter of the purpose, at least, and I'll take you to the legislation, it's to relieve those purchaser with only a fleeting or a transient interest, and ensure that in the property, and ensure that the burden of taxation is on the person with the use and enjoyment. And then in my submission, that is what section 45 does, construed purposefully, or even simply just construed. Doesn't need to be strained to reach that result. But just on that, I'd say that in my submission, you certainly can read section 45 so as to give effect to that clear policy result, which is only to relieve those with the fleeting or transient interest. And so even if there is another possible way of reading it, the court should favour, as the other tribunal did, the reading which gives effect to the policy and the purpose of the provision, which doesn't really make a nonsense of section 44, turning section 44 into something that it just wasn't intended to be. In other words, an exemption from tax, rather than a provision which identifies the right amount of tax and imposes it on the person who has the use and enjoyment of the property. And so what I say about section 45 is, it is important that it begins subsection 1A with the contract that's within section 44. So it's a contract for a land transaction is entered into under which the transaction is to be completed by a conveyance. And of course, here it's important that we're at a stage when it hasn't yet been completed. So there's a real contract. Here it's the one between Glendale and Mr. Fanning. The parties have entered into it, but it's not been completed. There will be a completion on a future date. And on completion, Mr. Fanning will become the new owner. So that is the nature of the transaction that you need to be within 45 at all, because that's described in 45.1a. So then in that context, when you read there's an assignment, subsale or other transaction, and actually what I'm going to go on to do is say, well, other transaction takes its colour or meaning from assignment, subsale, and so on. But if just reading it, standing back and reading it as a whole, there's an assignment, subsale or other transaction relating to the whole or part of the subject matter of the original contract, as a result of which a person other than the original purchaser becomes entitled to a call for a conveyance to him. In my submission, what it's doing is looking to the position on completion, and what it's asking is, as a result of that assignment, subsale or other transaction, on completion of the original contract, have you had a change in the purchaser? Has a person other than the original purchaser become entitled to call for a conveyance to him, so that now he's the owner of the property?
Yeah, and when they say a conveyance, what they mean is the conveyance, the sale. Yes. Although they say a, they mean the.
Yes. And it's subject to not to get bogged down in conveyancing detail. So it might be that in some cases the conveyance actually goes directly from the vendor to the sub-purchaser, or it might have to sort of pass through.
So there might be two TRL ones rather than a single transfer. Presumably, you're not saying section 40.
No.
Section 45 could apply in both situations.
Yes. So, but the conveyancing isn't. This isn't stamp duty. The conveyancing doesn't dictate it. What we're talking about is the substance of it, and it's all about a conveyance completing the purchase of the subject matter of the contract. And so that the contract in little a has not yet been completed. When it is completed by a conveyance, the purchaser will become the owner of the property, the subject matter. The freehold or the leasehold. And B just says, well, if in that interim moment there's a transaction where someone else is going to become the owner, then the rest can follow. And as long as you don't make a mistake and get your timing wrong, clearly you could enter into the right kind of subsale, and because you failed to complete on the same day, you would fail to get your relief, and that would just be a risk that you take. But in theory, you would be in a position to obtain the intended relief.
And you say it's going to become an owner is reflected in becomes entitled. It is talking about who will ultimately finish the day with the property in question, not somebody who may become entitled if another set of steps take place, the exercise of the option.
Yes, and the upper tribunal talked about the entitlement being, so if you focus just on the word entitled, being of the same nature or quality as the entitlement under the original contract. And an entitlement, I mean, this is really why I sort of focused on the point made in Peter Bone and the importance of a contract actually falling within section 44, is the right that the purchaser under an ordinary contract to complete by conveyance has to call for a conveyance is very different in nature to a contract where the purchaser only has an option to call. Because if what you've got is an option to call, the vendor can't. I mean, that's the point of having, if you've genuinely got an entitlement to call at your own election, then someone can't force you to take it. The transaction is different in nature. And so entitlement here just doesn't mean contingent entitlement or entitlement on the exercise of an option or contingent future entitlement. It's an entitlement of the kind which will mean that, if you look at it in terms of the deemed secondary contract, will still give you a contract to which section 4 can meaningfully apply, because you've got a contract which is to be completed by a conveyance. You might have had to needed the deeming to treat it to be a two-step contract, but so that's a sort of detail to get you within section 44. The substance of 44 is that what's being sold is the freehold or the leasehold title, and so you should have an entitlement to call for that, not merely an option to call. And all the other subsections of 45 all press you in that simple direction, which is that an assignment, subsale, or other transaction are all forms of subsales. And I mean, just perhaps in 2-3 minutes, just to begin with an assignment. So
Well, just to make clear, you're not being confined to the next 3 minutes.
Oh well, I could begin just at.
No, I don't want you to. I don't want to start all over again. But you have whatever time you need to complete your submissions. Always bearing in mind that shorter submissions are usually better than longer ones. So I'm not inviting you to restructure, but at the same time, we're not going to cut you off at lunch if you've got matters you want to deal with in the early afternoon.
I have got. I have got 1 or 2 more points on section 45, just to make sure I deal with all of the.
Well, I think the most convenient thing,
many.
because they'll probably settle in your mind when you have a moment to think about it, is we'll adjourn now. Roughly how long do you think you'll want after lunch?
Maybe half an hour, 40 minutes, if I deal with section 75A as well.
Right. And with a reply, when are we likely to be concluding the hearing?
If I could invite, if it's not trespassing on your patience too much, to if you've not had an opportunity to read our paragraphs at tab 15 of the upper tribunal, if you do want to hear submissions on 75A, I think I'd be no more than 15 minutes.
All right. Well, that's been satisfactory. Okay. Very well. Well, we'll resume then at 2 o'clock. Thank you.
All right.